Assalamu alaikum. I am Shaykh Al Hassan Johnny, Advocate Bangladesh Supreme Court. Today, we are going to discuss those particular sections of the Penal Code which Bar Council MCQ examinees often misunderstand or find confusing. I believe that Bar Council MCQ examinees often misread or misunderstand of sections 54, 55, 57, 70, 121, 124A, 325, 362, 376, 380, 391, 420, 464 and 511 of the Penal Code. Therefore, today we are going to critically discuss and analyze this section one by one so that you can clearly understand their meanings and application. But before I start my lecture, I would like to share a notice with you. Bonafide Law Academy has organized a special English version online course for the upcoming Bar Council MCQ examinees. This English version online course has been designed for British law graduates, barristers, students of the private universities, especially those who study and appear in exams in English. The classes will start on 20 December and 30 classes will be held in this course. Each class shall be provided with a separate lecture sheet. All classes will be held through Zoom meeting and recordings of all sessions will also be provided. British law students usually have limited knowledge of the legal system of Bangladesh as their education is mainly based on the common law system which is slightly different from Bangladeshi legal framework. Therefore, it becomes quite difficult for them to take detailed preparation. Since the exam is very near, they must adopt a strategic approach. They should focus on basic structured study to cover the major and important section within this limited time. I believe that this course by Bonafide Law Academy will greatly assist you in achieving a good preparation within a short span of time. So without any further delay, let us begin our main discussion. First of all, we will start our discussion with section 54 and 55 of the Penal Code. Section 54 of the Penal Code says that the government may commute the death sentence to any other punishment to provided in the Penal Code. On the other hand, section 55 of the Penal Code says that the government may commute the punishment of a person sentenced lifetime imprisonment to imprisonment for a term not exceeding 20 years. The common mistake we usually make here is that we often answer 20 years in both cases. But we must carefully notice that whether the question mentions death sentence or lifetime imprisonment. If it is death sentence, the government may award any other punishment to provided in the Penal Code, such as lifetime imprisonment, 7 years imprisonment, 10 years imprisonment. On the other hand, if it is lifetime imprisonment, then the government may reduce it to not exceeding 20 years. Now we will discuss section 57 of the Penal Code. Section 57 of the Penal Code says that when lifetime imprisonment needs to be converted into a fraction, it shall be considered as 30 years of rigorous imprisonment. The common mistake we make here is that we always think that 30 years of imprisonment, but the correct term is 30 years of rigorous imprisonment. After section 57, now we will discuss section 70 of the Penal Code. Section 70 of the Penal Code says that the general time limit for realize a fine is 6 years. But if the court awards imprisonment more than 6 years, the fine can be realized within the period of that imprisonment. The common mistake we usually make here is that we always think that the maximum period for payment of a fine is 6 years. But we often forget to notice that if the term of imprisonment exceeds 6 years, then the time allowed for payment of a fine will be equal to the period of imprisonment. Now I am going to make this point more clearer with an example. For theft, the punishment is 3 years imprisonment and a fine of taka 30,000. In this case, the fine can be realized within 6 years. For theft in dwelling a house, if the punishment is 7 years imprisonment and fine of taka 7,000, in this case, the fine can be realized within 7 years. Similarly, for assisting an adult in committing suicide, if the punishment is 8 years imprisonment and a fine of taka 5,000, in this case, the fine can be realized within 8 years. After section 70, we will now discuss section 121 of the penal code. Section 121 of the penal code says that declaring war against the state is punishable with death sentence. The common mistake that you usually make here is that since the punishment for waging war against the state is death sentence, many of you assume that it must be a cognizable offense. But you must keep in mind that the offense committed under section 121 of the penal code is actually a non-cognizable offense and the police cannot arrest a person without a warrant. After section 121, we will now discuss section 124A of the penal code. Section 124A of the penal code deals with the punishment for sedition, and under this section, the punishment for sedition is imprisonment for life or imprisonment for a lesser term with fine or imprisonment up to 3 years with fine or fine only. The common mistake that you will make in this section is that you often forget that under this section the court may impose only a fine as punishment. Therefore, you must remember that according to section 124A of the penal code, the court has the authority to award only a fine without imposing imprisonment. Now we will discuss section 325 of the penal code. In section 325, the punishment for voluntarily causing grievous hurt has been discussed. The common mistake that you usually make here is that section 325 was previously a bailable offense, but after the enactment of the Criminal Procedure Amendment Ordinance 2025, it is now considered a non-bailable offense. After section 325, we will now discuss section 362 of the penal code. Section 362 of the penal code deals with abduction. The point we must keep in mind regarding section 362 is that under this section, abduction itself is not offense. Rather, it is an ingredient of an offense and there is no punishment for abduction alone. When abduction is committed with a specific intent, it becomes an offense. After section 362, we will now discuss section 376 of the penal code. Section 376 of the penal code deals with the punishment for rape, and the punishment for rape is imprisonment for life or up to 10 years and fine. Section 376 also describes the punishment for committing rape on one's own wife. If the wife is under 12 years of age, the husband shall be punished with imprisonment for life or rigorous imprisonment for up to 10 years and shall also be liable to fine. But if the wife is 12 years or above but under 13 years, then husband shall be punished 2 years imprisonment or fine or both. After section 376, we will now discuss section 380 of the penal code. Section 380 deal with theft in dwelling house. According to this section, if theft is committed in any building, tent or vessel used for human dwelling or for the custody of property, the punishment is 7 years imprisonment and fine. The common mistake that you usually make here is that section 380 of the penal code does not deal only with theft in dwelling house. It also covers theft in any building, tent or vessel that is used as a dwelling house or for storing or keeping property. After section 380, we will now discuss section 391. Section 391 says that when 5 or more persons conjointly commit or attempt to commit robbery and any person present aids such commission, every one of them shall be deemed to have committed dacoity. The point we must remember from this section is that if anyone assists in the commission of a dacoity, his act will also be treated as dacoity. After section 391, we will now discuss section 420. Section 420 of the penal code deals with cheating and dishonesty inducing delivery of property. According to this section, the punishment for cheating and dishonestly inducing delivery of property is imprisonment for up to 7 years. However, the common mistake that many of you make is that since the punishment is up to 7 years, the offense must be non-bailable. But I would like to remind you that this offense is actually a bailable offense, not a non-bailable one. After section 420, we will now discuss on 464 of the penal code. Section 464 of the penal code deals with making false documents. According to this section, making a false document is not by itself an offense. Rather, it is an ingredient of forgery. When a false document is made with intent to commit forgery, it becomes an offense. After section 464, we will now discuss the last section of the penal code, which is section 511. Section 511 of the penal code deals with the attempt to commit offences for which no specific punishment is provided in the penal code. According to this section, if the penal code does not mention a specific punishment for the attempt of an offense, then the punishment for the attempt will be half of the maximum punishment for that offense or fine or both. Here, the common mistake that many of you make is thinking that only imprisonment is given under this section. But in fact, a fine may also be imposed along with imprisonment, and in some cases, only fine may be given.